Welcome to the lesson on property regimes on divorce or separation. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. This lecture examines how property is distributed when intimate relationships come to an end, comparing the position of married couples and civil partners with that of cohabiting partners. Although questions of ownership rarely cause difficulty during the subsistence of a relationship, they tend to arise sharply at the point of separation or divorce. It is at that stage that differences between legal regimes become most visible and, in some cases, most problematic. There are several reasons why property distribution on separation warrants separate analysis. First, ownership disputes are largely dormant, while a relationship continues but become unavoidable once it dissolves. Second, different legal regimes apply not only across different relationship types, but also within them. Even among married couples, outcomes on divorce may vary significantly depending on the facts. Third, as Elizabeth Scott correctly observes, marriage is surrounded by social norms, rituals, and expectations that contribute to its relative stability. Cohabitation, by contrast, lacks these stabilizing features, making separation more likely and, as a result, making disputes over property more common. Against this background, the comparatively limited protection afforded to cohabitants may raise concerns of unfairness, particularly when contrasted with the position of married partners. This issue is especially acute for individuals with lower incomes or lower levels of legal literacy. Berrington, Perelli-Harris and Trevena suggest, for example, that more highly educated individuals are more likely to expect childbearing to follow marriage, while less educated groups may enter long-term cohabiting relationships without fully appreciating the legal consequences of doing so. From a property law perspective, the starting point in England and Wales is that marriage or civil partnership does not automatically merge the property rights of the parties. Each partner retains ownership of assets acquired before the relationship, as well as assets acquired individually during it. This approach reflects a commitment to formal ownership and title, but it does not always align with the lived reality of shared contributions within a relationship. This rigidity is illustrated by a line of cases concerning beneficial interests in the family home. In Gissing and Gissing, the legal title to the home was held solely by the husband. The House of Lords found no evidence of a shared intention to co-own the property, and the wife's contributions to household expenses were insufficient to establish a beneficial interest. As a result, and rather harshly, she was held to have no proprietary entitlement. Note, however, that while the case remains historically relevant, following the decisions of Stack and Dowden and Jones and Kernot, it may no longer be considered good law. By contrast, in Grant and Edwards, the Court of Appeal found that a common intention to share ownership could be inferred from the parties' conduct, including significant non-financial contributions to the home. On the facts, the wife was awarded a 50% beneficial interest. These cases demonstrate that property law protection depends heavily on evidence of intention and contribution, rather than on the nature of the relationship itself. This approach was later clarified in Midland Bank and Cooke, where Waite L.J. emphasized that, in the absence of express agreement, the court must examine the entire course of dealings between the parties. This includes their financial arrangements, their sharing of burdens and benefits, and their conduct in relation to the property. Only where such an inquiry proves inconclusive should the court fall back on the presumption that equality is equity. The effect of this reasoning is that cohabitants' claims are resolved on a case-by-case basis, without reference to any overarching legal framework governing the relationship. From a family law perspective, the position is markedly different. As Anne Barlow remarks, upon divorce or dissolution of a civil partnership, the court approaches the distribution of property and income by asking what is fair and reasonable in all the circumstances. The justification for this discretionary approach lies in the need to protect economically weaker parties and to address imbalances created during the relationship. While this has historically tended to benefit women, the focus is formally gender neutral and applies equally in civil partnerships. In exercising its discretion, The court seeks to balance financial and non-financial contributions, recognizing unpaid care work, career sacrifices, and future earning capacity. Barlow notes that children are treated as particularly vulnerable members of the family unit, and their welfare is a central consideration in the allocation of resources. Chan remarks that three core principles guide the distribution of assets on divorce: need, compensation, and equal sharing. The principle of equal sharing, now well established in marriage, reflects the idea that marriage is a joint enterprise. Importantly, this principle does not apply to cohabiting relationships. Cohabitants remain confined to the outcomes produced by property law, regardless of the duration or nature of their relationship. This distinction is sometimes defended on the basis that cohabitation offers greater autonomy and flexibility. Unlike marriage, it does not impose mutual obligations of financial support. It has been suggested that this freedom justifies a more limited legal intervention on separation. However, this reasoning has been questioned, particularly where long-term cohabitation produces dependency and inequality comparable to that found in marriage. In Gow and Grant, a Scottish case decided after the introduction of statutory remedies for cohabitants, Lady Hale acknowledged both the need for legal intervention and the dangers of excessive prescription. While cautioning against rigid rules, she emphasized that legislation could make access to justice fairer, quicker, and less costly. The case also highlighted the growing divergence between Scots law and the law of England and Wales in this area. Importantly, the UK Supreme Court has indicated that the absence of mutual obligations during cohabitation should not necessarily preclude a fair outcome on separation. The court suggested that the principle of fairness need not be abandoned simply because the parties chose not to marry. This signals a degree of openness to reform. Support for reform is further strengthened by analysis of the Scottish experience following the Family Law Scotland Act 2006. Studies suggest that extending financial remedies to cohabitants has not placed excessive strain on judicial resources. However, Miles, Wasoff, and Mordaunt have cautioned that any reform must be accompanied by clear articulation of its purpose and principles in order to ensure predictability and legitimacy. In conclusion, the treatment of property on separation reveals a sharp divide between marriage and cohabitation. While property law offers some protection to cohabitants, it does so in a fragmented and uncertain manner. Family law, by contrast, provides married couples and civil partners with a coherent framework grounded in fairness, need, and shared responsibility. Evidence from Scotland suggests that extending similar principles to cohabitants in England and Wales would be both feasible and beneficial. Such reform is supported by the Law Commission and by academic commentary, which indicates that meaningful change need not involve disproportionate cost or complexity. Thank you for your interest in this topic. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.